Hi, my name's Greg McLawson. I'm the managing attorney at Sound Immigration. This is an overview of how we work with clients in adjustment of status cases for marriage-based green cards. Let's get started. Our first step working with new clients is to meet with them for an individualized consultation to ensure that they're eligible to pursue adjustment of status. In a sense, this is the most important step of working with the client. It's important because if you're not eligible to adjust status, you certainly don't want to proceed, as doing so could jeopardize your ability to ever reside in the United States. It's extremely important to make sure you're legally eligible before you ever begin preparing an application. Some common issues that we see in adjustment of status cases are the following. First, to be eligible to adjust status, you must have been lawfully inspected at the time you entered the United States. Those who were not lawfully inspected may not adjust status unless limited exceptions apply, such as an old immigration petition under what's called 245I. Likewise, you're not eligible to adjust status if you had the preconceived intention to seek residency at the time you entered on a non-immigrant or temporary visa. If you entered the U.S. on, for example, a tourist visa, with plans to adjust status, proceeding with an adjustment of status application could result in the application being denied on fraud-based grounds and a finding made that you are permanently ineligible to be in the United States. To sponsor a foreign national for adjustment of status, an individual must meet financial sponsorship requirements. These include income of a specified amount, and the income must be from a form of employment that is demonstrated to have been stable and can be relied upon by USCIS. Criminal issues, even minor criminal issues, can result in an application being denied. If the foreign national has any criminal background whatsoever, that has to be carefully assessed before the decision is made to proceed. Certain medical issues can also prevent an adjustment of status application from being approved. These include mental health grounds. If an individual has ever engaged in self-harming behavior, for example, that can result in a medical denial, unless a special waiver is sought. Similarly, any alcohol or drug use, including of legal marijuana, has to be carefully assessed, as there are both alcohol and drug-related grounds for denying adjustment of status applications. If we determine that a client is eligible to proceed, the next step is to prepare all of the legal instruments that are required for the adjustment of status application. Here's a list of all of the forms that go into an adjustment packet. Let's go through them briefly. The I-130 is what we consider the invitation from the U.S. citizen or resident. The purpose of the I-130 is to establish the qualifying relationship, in this case, a bona fide marriage, with the foreign national. The I-485 application is filed by the foreign national. This is the actual adjustment of status or green card application. The Form I-864 is the financial sponsorship document executed by the U.S. citizen or permanent resident. This is a binding contract with serious financial implications for the U.S. citizen or green card holder. If the U.S. citizen doesn't meet the financial sponsorship requirements by himself, an additional I-864 may be signed by a joint sponsor. Likewise, an I-864A may be signed by a household member of the petitioner in order to meet the financial sponsorship requirements. G-325As must be prepared for both the U.S. petitioner and the foreign national. These provide background biographical information about both. The I-131 is a travel authorization document. It's important because if the foreign national departs the United States while the Form I-485 is being processed, that application is considered automatically abandoned. So in order to allow for foreign travel if needed, we always file a 131 to ensure that the foreign national can leave lawfully without abandoning her application. The I-765, once approved, gives temporary work authorization. Typically, this takes between 3 and 4 months to process, but it gives the foreign national the ability to work while her green card application is being processed. Finally, the G28 is the notice of appearance form that shows our law firm is representing both the petitioner and the green card applicant. The forms, however, are just the tip of the iceberg, so to speak. Substantial supporting documentation has to go with the packet. Sometimes this can run to several hundred pages. It includes birth certificates, passports, and in marriage-based cases, substantial documentation is provided demonstrating that the marriage is bona fide or real. So how is our law firm helping while this packet is being prepared? Here's the stages that we go through when we're working with clients. First, we always meet with the clients for an initial project kickoff meeting once they've retained the firm. It's important for us to get organized and make sure that we and our clients are on the same page about how we're going to proceed with their packet preparation. This is done either in person or by Skype, whichever is more convenient for our clients. At the end of the kickoff meeting, we circulate homework assignments to our clients. These clearly outline the information that we'll need in the form of questionnaires, and also a document checklist showing very specifically each document that we'll need to prepare a successful application packet. Once the questionnaires are returned to us, we draft the legal forms required for the case. Because of our staffing arrangement, we can proceed very, very quickly to prepare these draft forms. In adjustment of status applications, draft forms are available within 48 hours of receiving the questionnaires back from our clients. Once we've prepared the draft, typically we will need to follow up with our clients because generally speaking, there will be some missing information from what we first received from our clients, or there may be things that we need to clarify. When our clients have provided that final information, the forms are revised again, and then the lawyer in charge of the case conducts a manual quality assurance review using a special process that we've designed to ensure the quality and accuracy of the legal forms. Once all the forms have been quality assurance reviewed and all supporting documents have been received from our clients, the packet is finalized and circulated to our clients for signature. Throughout this process, the attorney is always available to answer questions at no additional cost to our clients. The attorney may be reached through our secure client attorney system, or the client can set up an appointment online using our easy scheduling tool. Once the packet is filed, we will receive application receipts within approximately 10 business days. This allows us to track the progress of the applications online. Within 3 to 4 months, we would expect to receive the temporary work and travel authorization. Roughly 6 to 8 months down the line is when the interview would be scheduled, and we would again work with our clients to prepare for that interview. Once we receive the interview notice, we set up an interview preparation meeting with our clients. We walk through what to expect on the day of the interview, and this gives us an opportunity for the client to update us on any changed situations in their life. Often, we will ask for additional supporting documentation from our clients, especially for clients in relatively new marriages. We are permitted to supplement our packet with additional information at the time of the interview, and so often we'll ask for updated bank statements, utility billings, etc., to demonstrate that the couple is still residing together as a bona fide married couple. On the interview day, if our clients have elected to have us there at the interview, the lawyer will meet our clients at the USCIS interview facility and attend the interview with them. After the interview, we will expect a decision within 30 days. Very often we receive an approval at the interview itself, but it's also common for the USCIS officer to take the matter under advisement, and often they will issue the approval either later that day or shortly after. In the vast majority of our cases, the approval is received within 30 days. After the decision is made, the green card is physically produced by USCIS at a central facility, and typically the client receives the green card within 30 to 40 days of the approval notice. We hope this has been a helpful overview of our process. We're very proud at our extremely high success rate in marriage-based adjustment cases and hope that we have the opportunity to work with you.